Advanced Legal English, Advanced Legal English Vocabulary Lesson. And today we will delve into a contract law lesson. We will make out and analyze all the reading passages with the exercises with the best solutions and the detailed explanations. Now, I will give you the description of a commercial contract vision. So that's the drafting a commercial contract. Actually, the general advice when drafting a commercial contract is to draft a written contract that's complete and as precise as possible. The reason for this are twofold. Firstly, there is clear proof of the written term. Secondly, it reduces the risk of legal disputes. Actually, disputes may be lost in court. They can also be expensive, time consuming, and detrimental to the reputation of a company. A typical structure of an international commercial contract would comprise the following: heading setting out the type of contract, the names and the addresses of the parties, a description of the goods to be delivered or services to be provided, including quality, quantity, time, and more. Fixation of price and details of payment. Duties and rights of the parties, for example, warranty, payment of tax, duty, responsibilities, and many much more. Limitation of liability. Remedies in case of breach of duties, a confidentiality clause, the duration and the termination of the contract, a force majeure clause setting out circumstances excusing non-fulfillment in case of natural disaster, war, and etc. A clause on the governing law of the contract, an arbitration clause, signatures of the parties and date of signing, and appendices containing definitions, timetables, and so on. Here are some points to remember. First, for the terms to be clear and transparent, the process of drafting is not the time to negotiate merits of principle. This should be done before drafting commences. Second, clarity and certainty of expression are very important, as any ambiguity of expression is often construed by a court against the person who is trying to rely on it, particularly if he is the person who has drafted the clause. This is known as the contra referendum rule. Third, never express the same idea in two various ways in the contract. It is always better to repeat the same sentences. For instance, do not use the sentence to the best of the vendor's knowledge and belief in one place, and to be the best of the vendor's beliefs in another. Typical sources of mistakes in commercial contracts can be as basic as various date formats. For instance, 3/4 2010 may be interpreted as 3rd April 2010 or 4th March 2010. Or when mentioning currencies, dollars may be used as USD or Australian dollars. That's the difference. Of course, the use of standard clauses wherever possible is important, as such clauses are familiar to both sides and save valuable time and are likely to cover the important points. However, never draft in isolation. Make sure that the standard clauses actually cover what is intended by the parties. And fifth, also be aware of the law which can affect the contract. There are numerous sets of universal rules on contracts covering various aspects of international commerce and created by various institutions. The most important of these are the rules under the UN Convention on Contracts for the International Sale of Goods 1980s, The UNIDROIT Principles of International Commercial Contracts 2004 and the ICC Incoterms 2000. The application of these rules depends on several factors. The set of rules in question, whether their application is automatic or determined by the parties' agreement on their application, and whether these rules are available in all states. So first, our task is belong to our reading. We need to answer these three questions. The first question: what general advice would you give someone who is drafting a contract? Advice is you need to make it as complete and precise, I mean short, as possible. Second, what effects can legal disputes over contracts have on a company? They can be expensive and time consuming and can damage reputations. And the last question is what should be included in an international contract? Here are some bullet points answers to our question. A typical structure of an international commercial contract which comprise the following. A heading setting out the type of contract, the names and the addresses of the parties, a description of the goods to be delivered or services to be provided, including quality, quantity, time, and etc. Fixation of price and details of payment. Duties and rights of the parties, for example, warranty, payment of checks, duty, responsibilities, and so on. Limitation of liability. Remedies in case of breach of duties. A confidentiality clause. The duration of the contract and the termination of the contract. A force majeure clause setting out circumstances excusing non-fulfillment in case of natural disasters, wars, and so on. A clause on the governing law of the contract, an arbitration clause, signatures of the parties, and date of signing. Also wise appendices containing definitions, timetables, and many others. Actually, we have already read the second and the first part of the guide, and now we need to answer these questions. First, why should contract negotiating be done before the drafting stage? To allow the contract terms to be transparent and clear. The next, what is the contract referendum rule? That's a rule of contractual interpretation where the party that insisting on an ambiguous term being in a contract won't get the benefit of it. Third, what is the basic rule for expressing the same idea more than once in a contract? Keep it exactly the same. Fourth, why is it a good thing to use standard clauses when drafting a contract? They're familiar to those involved and can save time. Fifth, find two examples of typical mistakes, dates and currencies. And six, what are the three most important sets of universal rules on contracts? That's CISG, UNIDROIT principles, and ICC Incoterms. Let's go to the language, work, and vocabulary section. We need to write the adjective related to each of these nouns. First, ambiguity, ambiguous. Second, availability, available. Third, confidentiality, confidential. Liability, liable. Advisability, advisable. And typicality, typical. And the next, some words from the text are often confused with others. Let's go. Warranty and guarantee. Here are the answers. Warranty, that's specific written guarantee to cover repairs, replacement, and many others, but guarantee more general. Second, set and group. Set, that's a group of things that belong together. Group, more general. Okay. Such terms and clause terms where a contract does or even doesn't do, and clause where the terms are contained in a contract. Force, duty, and right. Duty, something that has to be done as responsibility, and right, something that is allowed. Fifth, termination and finalization. Termination, this is the ending of something, and let's say the contract. Finalization, the completion of something to be done. Six, comprise and include. Comprise, these things form, include, these things are part of. Seventh, remedies and arbitration. Remedies, that's the methods of getting redress and compensation. And arbitration, that's the form of dispute resolution and alternative to court. Eight, construed and believed. Construed, that interpreted, believed, thought to be. Ninth, numerous. That's a lot of, many. A number of, this, several. And the last task and exercise is we need to complete the sentences to fill the gaps with the correct words from the exercise course. Okay, so first, the warranty on my car runs out in 2 months. That's the warranty, not guarantee. The second, what remedies are available? Or, so that's why we need to write remedies instead of remedy. To the injured party in the case of breach of contract, the public has a duty to report any wrongdoing to the authorities. Forced termination of an employee's contract of employment can lead to legal action. And the fifth, a number of people have applied for the position and will be interviewed soon. So, if you would like to get more like of this advanced legal English and advanced legal vocabulary lessons, kindly ask you to subscribe my YouTube channel for free and valuable lessons. Also, wise, you can easily download all the materials that you need through my Telegram channel. And also, wise, I advise to actually join my Telegram channel for all of these materials. Thanks for watching.